Appreciate everyone being here, given the weather activity. We'll begin argument in Schwartz versus Rent-A-Wreck. Mr. Jansen.
Good morning. And may it please the court, my name is Dan Jansen. I'm from the Quarles and Brady Law Firm in Milwaukee, Wisconsin. My clients this morning are Rent-A-Wreck of America, Inc. and Bundy American, LLC. With the court's permission, I will refer to them for convenience together as Rent-A-Wreck, and I will refer to the appellees as Mr. Schwartz. Before I begin, I want to thank the court for agreeing to hear this case a second time. It was almost 3 years ago to the day that the parties were before this court. It was a privilege to appear before this court in 2012, and it's a privilege to be here today. Now, this morning, the most important case law authority happens to be this court's first decision following the first appeal between the parties, argued on January 26, 2012, and issued on March 9, 2012. Its plain meaning, the plain meaning of this court's decision is what is at issue today. Now, at the time of the first appeal, this court was dealing with an appeal following an April 2010 jury trial to the district court. Now, at issue in the first district court trial was the nature of the relationship between Rent-A-Wreck and Mr. Schwartz. And following that first jury trial, the jury defined the relationship between the two as having 5 elements. That it was a franchise with an exclusive territory, where Mr. Schwartz had the same franchise obligations to Rent-A-Wreck as other franchisees, with the exception of the payment of royalties and the duration of the franchise for Mr. Schwartz's life. Following the jury trial on motions after verdict, the district court upheld 3 of those jury findings. The district court upheld the findings that there was a franchise contract that was exclusive for the lifetime of Mr. Schwartz, but the district court overturned 2 of the jury's findings, namely the jury's finding that Mr. Schwartz owed the same obligations to Rent-A-Wreck as all other franchisees, and overturned the jury's finding that Mr. Schwartz was obligated to pay franchise fees to Rent-A-Wreck. Now, insofar as the district court's rulings after verdict were concerned, the issue before this...
You're talking about what preceded the first appeal, right?
Yes, Judge.
Well, that's kind of water over the dam. I mean, we're actually dealing here with the remand, which was, we asked the district court to find out whether the exclusive franchise violated California antitrust laws, and that's what we asked the district court and the jury to do, and that's what they did. And I don't understand why all this lengthy discussion of the activities prior to the first appeal has much relevance to what we asked the jury to do.
Well, and that is the issue today. But a single issue was remanded by this court to the district court. The single issue of whether the exclusive territory foreclosed competition. But importantly, the district court took upon itself not only to conduct that jury trial, but also to exceed its mandate and to make rulings that are embodied in at least 4 of the orders that are part of the record beyond the mandate. Namely, the district court determined that it should itself define what those obligations were and the nature of those obligations. It was a very simple issue. The jury found that Mr. Schwartz owed obligations. The district court overturned that finding, and it was reinstated by this court. When it was reinstated by this court, in its opinion of March 9, 2012, there was nothing further for the district court to do other than conduct this jury trial. But
when it went back, you introduced a new agreement or proposed new agreement and an operating manual and filed another counterclaim and things like that.
Well, it's not so much a matter...
Judge Duncan. Couldn't do that.
No, please go ahead.
Yeah, I mean, it's not so much a matter of introducing another agreement. Rent-A-Wreck was simply exercising its rights that were granted to it by this court. This court said the jury made the correct decision. That is, Mr. Schwartz owes the same obligations to Rent-A-Wreck as all other franchisees. All other franchisees sign franchise agreements. It is the written franchise agreement that embodies those obligations. So, taking advantage of the relief granted by this court, Rent-A-Wreck simply presented its franchise agreement to Mr. Schwartz, asked him to sign the franchise agreement, as it does with all other franchisees, and advised him that it expected Mr. Schwartz to honor these obligations with two exceptions. The two exceptions noted by the jury, the payment of franchise fees and the duration of the franchise for the life of Mr. Schwartz.
Could I, I don't want to interrupt your answer, but there is one thing that it would help me if you would clarify. You said that the district court took it upon itself to issue an order concerning the nature of Schwartz's obligations to Rent-A-Wreck. Did I understand you correctly to say that?
Yes, but more than one order.
No, just bear with me, please. I wanted to know, is there an order in which the district court did that was not suspended? Is there an operative order in which the district court defined the obligations that Schwartz owed to Rent-A-Wreck?
The district court began doing that in a series of 4 orders. The first beginning in the order of January 23, it's in the joint appendix at page 499, and ending with the court's memorandum of July 19, 2013. That's in the joint appendix at page 914. In each of these 4 orders, the district court began describing the conditions and limitations that it would apply to the obligations that Rent-A-Wreck was going to enforce on Mr. Schwartz.
It seems to me, though, that perhaps you are answering my question no, because I couldn't find an order in which the district court imposed terms and conditions, specific terms and conditions on Schwartz that it didn't suspend as part of its order until after oral argument in 2013, when the district court, in accordance with both the parties' wishes, canceled oral argument and closed the case. I mean, there are certainly memoranda in which the district court discusses the issue. But I'm trying to find out, and I'm actually trying to understand, is there a definitive order?
Well, the definitive order suspending Mr. Schwartz's duty to have obligations to Rent-A-Wreck is February 28, 2013. That's in the joint appendix at page 556 and continuing on 557. The court uses the term suspension. Now, thereafter, and after the jury trial, the district court continued to assert that it had the jurisdiction and the authority to define the obligations that Mr. Schwartz owed to Rent-A-Wreck. And Rent-A-Wreck continued to object and to object to the briefing schedule and the hearing that had been set in September.
Are you appealing that? I mean, are you appealing any particular condition?
The district court suspended Mr.
But you're not appealing any particular obligation that the district court did or didn't impose on Mr. Schwartz vis-a-vis the other franchisees.
Well, I am, because the district court suspended those obligations in its order of February 28, 2013. According to the district court, Mr. Schwartz has no obligations to Rent-A-Wreck. That's the reason why we're here. The district court should never have engaged in this exercise in the first place. The first jury, it's a verdict upheld by this court, held that Mr. Schwartz has the same obligations to Rent-A-Wreck as all other franchisees. At that point, at the time that this court affirmed the jury's finding, there was no further action to be taken by the district court.
Where did the district court hold that Schwartz had no obligations to Rent-A-Wreck? I thought on, let me see, page 4, 499 to 499, 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 4 remand, the court entered an order declaring Schwartz subject to the terms and provisions in the 2011 agreement with certain exceptions. Now, it ultimately suspended that order because you were supposed to go to oral argument in September 2013. But it canceled the oral argument because the parties so requested.
Because the court was engaging in a process that it had no authority, no jurisdiction to do in the first place, and that includes the January 23, 2013 memo. The court had no jurisdiction to even make the finding that the franchise agreement of 2011 was effective, and in that same order hold that it is effective except to the extent that Rent-A-Wreck may unduly pressure Mr. Schwartz. The entire exercise...
If I may, then, in response to Judge Wilkinson's question, specifically, what order are you appealing?
Well, I am appealing 4 orders, the January 23, the February 28, the May 17, and July 19 orders. All 4 involve the exercise, the inappropriate exercise of the district court beyond the mandate rule to define and describe and limit the scope of Mr. Schwartz's obligations to Rent-A-Wreck, which the district court had no authority to do. The only thing the district court had the authority to do was to conduct a jury trial on the issue of whether there was a foreclosure of competition based on the exclusivity of Mr. Schwartz's territory.
Are you complaining about that jury trial and the result of it on appeal?
Yeah, there were 2 problems with that. The first was that the district court misallocated the burden of proof, number 1.
Okay.
And the second is that the district court inappropriately, before trial, ruled that Rent-A-Wreck could not present its theory of the case on substantial foreclosure of competition.
That was it, whether there were any other Rent-A-Wreck franchises in the territory? The judge defined the market as the rental cars, right? And which is what you all alleged in your complaint. The one you filed after a remand. You filed an amended complaint or counterclaim and said it was rental cars. And then when you got up to the day of the trial, you changed it. Said, "Oh, it's not rental cars, Judge. It's whether Rent-A-Wreck franchises." Well,
no,
he said, "Well, if we do that, we don't need a trial." And so then the jury ruled against you.
but that's where the
And
district...
that final order is August 23rd, 2013. You're not appealing that? That's the final order and judgment on remand.
It's being...
And that's not one of the orders that you claim you're appealing. That's the one you have to appeal, I thought.
Well, I believe we are appealing that final order as well, but the problem is that the court mischaracterized Rent-A-Wreck's theory. Rent-A-Wreck did define the line of commerce as rental cars between 2 and 8 years old. It wasn't the sale of franchises in the territory, and in the record, and I can get you the specific number in the appendix, we have the expert's report that was excluded. The problem is, I believe that the district court mischaracterized Rent-A-Wreck's theory.
All right, well, you have some rebuttal time. Thank you.
Thank you.
Mr. Simmons?
Thank you, Your Honor. I'm Roger Simmons. I represent Dave Schwartz. Been through 2 trials for him. My capable colleague here, Jake Weddle, has been through those trials with me, argued the first appeal, and I'm here to try to answer any questions the court may have. One question I want to get to as quick as I can, Your Honor, is Mr. Jansen's assertion that they didn't change the theories. Judge King, you're absolutely right. If you look at appendix page 559, you will see the amended counterclaim that laid out their theory, which was in accord with the mandate that Judge Duncan wrote in the opinion that the panel adopted. But the day before, or not the day before, but couple of weeks before trial, a pretrial order was submitted by Mr. Jansen and his clients that changed that theory in appendix 790 to the line of commerce in this dispute being the sale of Rent-A-Wreck brand franchises for renting and leasing used motor vehicles that are less than 8 years old. And that's what the trial court had a problem with. In this case, the mandate never was about the sale of franchises within West LA. It was about the foreclosure or not non-foreclosure of rental car leasing efforts in LA. We have a demonstrative.
Well, now, he's claiming that the district court violated the mandate rule by inquiring, the simple act of inquiring into the obligation that the other franchisees had toward Rent-A-Wreck. And what do you say about that?
Your Honor, as the court recognized in the first opinion, this is a somewhat unorthodox situation. David Schwartz never signed a rental agreement, as Judge Duncan noted at page 242 of the original opinion. He never signed an agreement. The 2011 document was never
Does that matter? I mean, we found that there was an implied contract through
Yes.
the course of dealing, so I'm not quite sure.
There was an implied contract, Your Honor.
Well, could you respond? I shared Judge Wilkinson's question, and I was wondering if you could get to that.
That being the obligations?
What the district court asked about on remand. The jury in 2013 indicated that Rent-A-Wreck has the right to exercise some control over Schwartz, right? As is necessary to protect its trademark, trade name, goodwill. And it also found that Schwartz's exclusive territory does not foreclose competition in a substantial share of the marketplace. So that's where we are after the jury.
And I was going to try to answer that question with this point, Your Honor. I apologize for stepping in before I should have. The trial, the second trial, was a free and open trial on what was required of the different franchisees. There was extensive evidence introduced on whether, in fact, Rent-A-Wreck actually required the things that it tried to impose in this new contract, this new written document that had never been a part of any relationship with David Schwartz. It tried to impose that on him, asserting that these things were required of other franchisees. And in being tested, we found that no other franchisee was ever required to do those kinds of things.
It seems to me that perhaps your best argument goes back to what Judge Duncan was asking opposing counsel earlier, and that is what is really before us on appeal, and this whole idea of what obligations other franchisees owe or what agreement controls those other obligations is all in a very vague situation.
Exactly.
So what is really at stake here is whether this individual has the right to exercise his exclusive franchise. And basically, what I understood, I wasn't on the panel, but what I understood the prior appeal to say, well, yes, he does as long as there's no anti-competitive effect under antitrust law or California law. And that question was answered by the jury, and it's hard to see how the jury's answer was erroneous because the Western Los Angeles rent-a-car market has got to be vast.
It is.
Unless you try to narrow it to Rent-A-Wreck franchises, which he would be the only one, and by definition of monopolization, and we couldn't have intended that because that would have been amenable to a judgment as a matter of law rather than a jury trial. But what we, as I understand it, what's really before us in real world terms is whether this gentleman gets a chance to exercise a royalty-free, exclusive franchise in a vast market. The jury seemed to return a verdict saying, Yeah, there's no anti-competitive effect under California law. There was evidence taken as to the market and to the number of rent-a-car operations and the rest, and sending it to the jury on that issue and having the jury answer, it seemed to me exactly what our earlier opinion contemplated as to this other issue about obligations. If it's not a red herring, I don't know what it is, but it certainly is up here. If it is up here at all, in a very vague and unsuitable way, and I come back to Judge Duncan's question, because I can't get my arms around this same obligations question, because I don't really have a judgment or a judgment order or a specific sense of what the obligations are or whatever. I mean,
That was never part of the trial. It was never put to the jury, never found by the judge.
Well, that's I don't know that that's correct. That to some extent, as a result of our last opinion, we said the same obligations with the two exceptions, the lifetime, as other franchisees. And the jury found that, yes, Rent-A-Wreck has the right to exercise some control as it would over other franchisees to protect its trade name, et cetera. But that still leaves what is the nature and extent, what are those obligations and responsibilities? And it's hard for me to see where it seems to me that did necessarily flow from our prior opinion, and I'm having trouble finding a place where the district court spoke definitively to it.
Your Honor, what the jury found, is my understanding of what it was that the relationship that existed between Dave Schwartz and the now entity was such that it exercised and had in the past and throughout the history exercised enough influence on David Schwartz's operation to protect its mark. In fact, he was, in the words of the PR guy for Rent-A-Wreck itself, who was a witness of Mr. Jansen at trial, David Schwartz was a goodwill god to the industry because he made people happier renting Rent-A-Wreck cars than any other franchisee. And he was doing nothing to impact or hurt or harm the trademark. And the influence they had on him was one of day-to-day contact, day-to-day discussion, day-to-day influence. But as to the actual terms, can you go in and audit his books where he doesn't have any obligation to pay fees? Can you require him to spend $5 million in 30 days to increase your fleet size in LA? No, they didn't say that he had that obligation.
I think you're actually agreeing with me.
Yeah.
I mean, I think actually we're saying the same thing. That there was some control necessarily.
There were some controls,
flowed,
and the jury
but
found sufficient.
But the question was, what was the nature of that control?
But that issue was never put in this trial, in this appeal, or in this mandate.
Well, not yet. So you're agreeing with me on that, or you're saying that you can't identify a document or order that spells that out.
But it never found its form in a
Post-jury trial.
document. It never found its form. And as Your Honor noted, it was a contract, an applied contract that grew out of a course of dealing over years.
No, but
David Schwartz never signed an
That's
agreement.
not my question.
Oh,
My
I'm
question is what the district court ordered or what was resolved post-June 2013.
By agreement of both parties, we asked him not to do that.
One of the things is, with my difficulty with the lack of concreteness of the same obligations question, if Mr. Schwartz violates what Rent-A-Wreck thinks is an obligation, then they would have every right to bring a breach of contract action or an implied a breach of implied contract action or something of that nature. But then we would have a situation where there had been, we say they're subject to the same obligations. And it seems to me, rather than having the district court maybe spell that out in the abstract, that it would be best to leave it to the fact that if he violates what they think are their obligations, then Rent-A-Wreck going forward would have a right we've set the parameters. And as to the specifics, why wouldn't that await a future breach of contract action if there's some dispute at some future date over compliance with the obligation?
I would say this to Your Honor.
I mean, why do we have to wrap all that up here or remand it and have a third appeal, which we would have?
Please no, but I don't believe that's necessary. There's no ongoing dispute on that at this point. There's no case that puts it in concrete. We can look at it. And
There's no ongoing dispute as to what? The nature
as to
of...
the nature of his obligations, because as the jury found, looking at the conduct and the obligations imposed upon other franchisees, they had sufficient control over this man and exercised sufficient control over this man to protect their mark. And he who had developed the
those obligations, but whether he violates, it's clear he's subject to those obligations. But whether he violates those obligations and what obligations they are, I don't know that I can tell at this point. And it would seem to me to have to await some concrete violation and somebody bringing a breach of a cause of action for breach of contract or breach of implied dealing or what have you. I just don't know that that either we or the district court ought to be doing that in the abstract until there's some dispute between the parties of a violation.
Judge Wilkinson, you have it exactly right. At this point, the only thing that was resolved was the actual mandate. Was there, what the market was the leasing of rental cars in LA, West LA, and was that exclusive right an antitrust or a Cartwright violation in California? Those two issues were resolved. We're back here with the claim that somehow that mandate was not followed. It was followed to the letter. The jury verdict form, which your honors will find at page 902 of the appendix, is in the literal words of this court's opinion and directed back on remand. The fact we have here is it is an implied contract. It wasn't something that someone created in 2011. It was something that was created in mid-1970s, and for 40 years after that, there was a relationship that grew out of the implied and ongoing course of dealing that went forward between 1974 and 2013 when the trial was had, and now 2015, 41 years later.
If there is no question about the nature of the obligations, are you agreeing that, it seems to me that you're conceding that you would be bound by the obligations in the 2011 franchise agreement?
No,
but that's part of the problem. Because
No.
Let me finish.
I'm sorry.
Apparently, there is a 2011 franchise agreement.
But it's not.
Please don't interrupt me. It seems to me that there is some standard out there that there's the 2011 franchise agreement that sets forth obligations that Rent-A-Wreck claims that Mr. Schwartz is obligated by. So it would seem to me that there is a question about the applicability of those obligations across the board, given, or there could be a question about the applicability of those obligations across the board, given that the court said that the obligations and responsibilities would be the same.
The court didn't quite say that. It said if he wanted the same benefits, then he had to comply with the obligations.
So I,
But the evidence, the evidentiary record was different than that. The evidentiary record was that none of the other franchisees, in fact, followed anything in that 2011 document they were trying to use to terminate him.
Is that the purpose of all those pictures and things y'all put into the appendix?
Yes, Your Honor. They made the claim. Yeah.
Where you had people renting Penske trucks at the same place, and you sold used cars
Yes.
at the same as the Rent-A-Wreck, and they did everything.
Yes, the franchisees across the country did everything they claimed was contrary to what they wanted to force Schwartz to do. And the guy that put up as the sole source of evidence was a man who had not visited any franchise except Dave Schwartz's, had done nothing to.
None of that had anything
No.
to do with the issue of who was, what the rental car market was in West Los Angeles.
No, but it had to do, Your Honor, with
You had
whether or
money
not.
there from Greensboro, North Carolina, and
Yes.
up in New York State.
What it had to do with was he doing and required to do what was necessary to protect the mark as other franchisees? And that's how it fit into the case and why it was relevant. It was the first of the two questions. And that's how it got relevant. I don't want to take the court's time if there are no more questions. Thank you, Judge Duncan. I apologize again for, I think I understand where you're going, and I try to answer it before you've articulated it. And my sincere apologies. I did not mean to be disrespectful.
well, I appreciate that, and I'm sorry to have bombarded you with questions.
Oh, that's why I'm here, and I apologize, Your Honor.
Mr. Jansen, you have some rebuttal?
I believe the point that you made, Judge Wilkinson, in your question of opposing counsel is the right one. And that's what should happen here if there is a dispute between the parties on what actually the obligations are. And if that dispute arises, then Mr. Schwartz would do what any aggrieved party would do if the facts support it, which is to file a new lawsuit and claim that there is a breach of contract. And then in that dispute, the parties might differ on what are the terms of the contract and were the terms of the contract followed. The important point was this was not for the district court and for Judge Massetti to treat the jury's verdict as if it were a permanent injunction over which he had the authority to act as a referee of disputes between Rent-A-Wreck and Mr. Schwartz indefinitely.
Is there any dispute that as a result of our prior opinion, that Mr. Schwartz is subject to the same obligations as other franchisees, and that he's not just free to run around with an exclusive franchise and have no obligations with respect to the Rent-A-Wreck? I mean, I don't on the general parameters of the problem, I don't know if there's any dispute. It's just the concrete question of violation. I just wonder whether, either party could bring a breach of contract action at some point in the future if they felt that their rights were being violated. Given how litigious they are, I suspect it will happen.
I don't know whether that will happen or not, although this is the second time that we are before this court. But what I will tell you is the procedure you describe is absolutely appropriate for the next litigation, if there is a piece of litigation. What I know with certainty is the district court didn't have the jurisdiction or the authority to start sorting through those issues in advance, which is exactly what happened in July 19, where the district court determined that it would start determining for itself, with no particular standard, the fleet size, whether Rent-A-Wreck should have the ability.
But it stopped. It stopped, right? I mean, it canceled the oral argument into which it was going to go into those details, and everything you say is making perfect sense. Help me understand, what precisely do you want us to do with this appeal, the appeal that's currently before us? How do we get to the point that there seems to be some consensus would be useful? That is a breach of contract action. What becomes of this appeal?
Well, we have appealed the final order of judgment on remand. That's in the appendix at 924, as described on the first page of our brief. The orders leading up to that final judgment on remand are those that are described in the last page of our brief, and those orders should be vacated. As we sit here today, based on the district court's rulings leading up to the final order of judgment, a ruling has been made that Mr. Schwartz does not have the same obligations as every other franchisee.
Where is that ruling in the record? Where did the district court do that, in your view?
That is the suspension of the earlier orders on February 28, and the district court then acting on its self-appointed grant of authority in the orders that follow.
What practical effect any of this, I mean, maybe there was some thrashing around, but what practical effect did it have? I mean, you know, people go down blind alleys all the time, and you know, what, as he was, I mean, he was making these inquiries and everything, but you can argue about whether he should have been making them, but what practical effect did it all have, just on your client right here and now?
Well, the practical effect is we have a district court that has ruled, in our view, that it has the continuing authority to act as a referee in disputes between Mr. Schwartz and Rent-A-Wreck, and all I am asking this court to do is to confirm that the issue was answered once and for all by the first jury, that there was reasonable evidence for that jury's conclusion as affirmed by this court in its first appeal, and there is nothing further for the district court to do. Everything that the district court did leading up to that final order of judgment on remand, which we have appealed, was beyond the scope of the mandate rule.
He tried the very issue we sent back, and they found it against you about that, whether the rental car market in West Los Angeles.
Well, but that is...
But that was part of it. That was what we sent back to try that, and you tried it. You tried it, and you say allocated the burden of proof wrong, but you don't complain much beyond that. Sounds to me like there's a lot of egos involved here, and people don't talk to each other, or lawyers don't deal with each other. You're supposed to submit a joint pretrial order, and you each submitted their own. You wouldn't even talk to each other. You want us to settle it now.
The part of what you're concerned about is the nature of the respective obligations, and you think that the district court should have left that part alone.
There was nothing more to do. I have no problem. My client has no issue with the fact that there was a second jury trial as this court ordered the district court to do. It conducted a jury trial, and the jury issued its form of special verdict.
At that point, are you willing to accept the fact that you lost and that jury trial was conducted in an appropriate manner?
No, because we are appealing that jury trial in two respects, and we're asking for a new jury trial because of, number one, the misallocation of the burden of proof, and number two, the fact that the court made the mistaken ruling that as a matter of law, Rent-A-Wreck's theory...
If we try to sketch out and flesh out, I mean, this goes to show how litigious it's going to be forever. I mean, if we try to sketch out and flesh out what the obligations are on this appeal without any concrete breach of contract action as the foundation or any concrete violation, there's going to be another argument over the scope of the opinion and the mandate and the rest. You know, I'm just afraid we'd be coming close to writing the party's contract for them, which is a very difficult thing to do given that there are various agreements which might or might not apply, and given the fact that, you know, there are implied courses of dealing involved and the rest. I'm just thinking this is very hard for us to do. I think it would be a nightmare for the district court to try to do in the way that the present case is at too abstract a level. If these parties have a contract and an understanding between them, then if that understanding is violated, let it come before court, probably a state court. that point in time. But sometimes if people try to get us to do too much in an appeal. So simply write an essay. I don't know that that's a good idea.
May I respond even though I'm
Very
over time?
quickly, because your time has expired.
I agree with absolutely everything you just said.
No, you really
This,
don't.
this court and the district court should not rewrite the parties' agreement. The jury has already defined the parties' agreement.
Okay, thank you.
Thank you.
We'll come down, recouncil, move into the next case.